All right, this is super important, and I want to go over this as briefly and succinctly as I can. This has to do with one of the two charges laid at the feet of Jose De Castro in Nevada, and that is obstructing a public officer. Now, there's a lot of debate on what obstructing actually is according to the law books. What's interference? What's obstruction? It has to be a physical act, some people say, and other people are saying, well, if it's a physical act, then you need to prove that in the revised statute, and that revised statute is 197.19. And before I go further with this, I want to thank the guy who commented under Barry Cooper's last video entitled Barry versus James Freeman versus Chili De Castro, where Barry offers up a bit of criticism for James Freeman's comments on the Chili De Castro thing. And we could probably go over that in the future and maybe talk to Barry himself, which I would definitely be open to. But Jimbo Jones right here brings up a case called Wilson versus the First Judicial District Court of the state of Nevada. And I hadn't heard of this, but I want to go over it because I think it's kind of important. And I wonder, because I'm not a legal expert, I wonder if it's germane to this particular issue dealing with Chile versus the state of Nevada. And I just want to read to you a couple of paragraphs from here. This is very, very lengthy. I'm not going to go through all of it. I don't want to bore you, but it's super interesting on the opinion that the court gave. This is per curiam, which means the decision of a judge or court in unanimous decision. And they say, in this opinion, we consider constitutional challenges to NRS, that's Nevada Revised Statutes 197-190, which provides that a person may not willfully hinder, delay, or obstruct any public officer in the discharge of official powers or duties. What we'll do is we'll actually read the entire thing right here. It says, every person who after due notice shall refuse or neglect to make or furnish any statement, report, or information lawfully required of the person by any public officer, or who in such statement, report, or information shall make any willfully untrue, misleading, or exaggerated statement, or who shall willfully hinder, delay, or obstruct any public officer in the discharge of official powers or duties shall, where no other provisions of law applies, be guilty of a misdemeanor. What's really interesting about this is the conclusion they arrive at of what is obstructing. What does obstruct any public officer mean? So they say petitioner Lena Marie Wilson was charged with and convicted under NRS 197-190 after yelling from her yard at several police officers who were attending to a separate, potentially life-threatening manner involving a juvenile on the street near Wilson's house. So she's saying stuff to police officers from her yard, and we're going to read that too in a second. After the district court affirmed her misdemeanor conviction, Wilson petitioned for a writ of certiorari, which means an appeal to a higher court to examine the decision of a lower court, arguing that NRS 197-190 is unconstitutionally overbroad or vague. We conclude, this court says, the higher court says, we conclude that this NRS applies only to physical conduct or fighting words that are specifically intended to hinder, delay, or obstruct a public officer, and therefore NRS 197-190, as construed by this court, is not unconstitutionally overbroad or vague either on its face or as applied to Wilson. But then they make a suggestion to the lower court that is super, super interesting. They say, although we hold that Wilson's as-applied claims fail, we recognize that Wilson's claims implicate the sufficiency of the evidence in light of our interpretation of the NRS. And then they say, since the district court did not have the benefit of our interpretation of this NRS 197-190 as applying to only physical conduct and fighting words, it did not consider whether there was significant evidence to support Wilson's conviction. So it's like, hey, okay, you convicted her according to this Nevada revised statute, but now why don't you take a look at it in light of our decision that this only applies to, quote, physical conduct and fighting words. Physical conduct and fighting words, not just exercising freedom of speech, which fighting words, they say, are not covered by the First Amendment. Accordingly, we grant the petition and direct the clerk of this court to issue a writ of certiorari upholding NRS 197190's constitutionality and instructing the district court to reconsider Wilson's direct appeal for the sole purpose of addressing whether, under this court's interpretation of NRS 197190, sufficient evidence supported Wilson's conviction. And guess what court case they refer to? The two court cases, Chaplinsky versus New Hampshire and City of Houston versus Hill. So let me give you a quick rundown of the story of this Wilson case. On March 25th, 2021, which is before what happened to Chili, the Carson City Sheriff's Office responded to a call indicating that a juvenile was contemplating suicide. Sergeant Mike Cullen was the first officer to arrive and saw the juvenile walking down a residential road with a knife in his hands. Sergeant Cullen followed the juvenile in his car and attempted to communicate with him. At some point, the juvenile stopped in the street and Sergeant Cullen got out of his car and continued to communicate with the juvenile from a distance. The juvenile pressed the knife into his body a couple of times and stated he wanted to kill himself. And in accordance with his training, Sergeant Cullen attempted to build rapport with the juvenile to prevent the juvenile from committing suicide. Shortly thereafter, more officers arrived on the scene. One officer, Deputy Nicholas Simpson, maintained a position with a beanbag shotgun while the other officers attempted to de-escalate and control the scene. Deputy Simpson was to use the beanbag shotgun if the public or the officers became at risk. Approximately 15 minutes after the officers arrived on the scene, the juvenile dropped the knife. Sergeant Cullen believed the situation was unstable up until that moment. At some point during these 15 minutes, while the officers were interacting with the juvenile, Wilson, who lived next door to where the incident was taking place, started yelling at the officers and the juvenile from the middle of her front lawn, and Wilson continued to yell at the officers, even though two deputies asked her to stop yelling several times. The officers generally could not recall what Wilson was yelling, although Sergeant Cullen heard Wilson yell at some point that she was a witness of some sort. Deputy Simpson testified that he asked Wilson to stop yelling between 3 and 5 times. The officers testified that Wilson did not leave her yard, did not threaten them with violence, and did not throw anything at them. Nevertheless, the officers testified that Wilson's yelling was loud and disruptive and delayed their attempts to get the juvenile to drop the knife because it interfered with their ability to build rapport and interact with the juvenile. Deputy Simpson also testified that he had to put down the beanbag shotgun to address Wilson because of her yelling, which put the officers at risk. Eventually, Wilson's behavior, quote, stopped enough to where the officers were able to get the juvenile over the curb and the juvenile dropped the knife. Thereafter, the state charged Wilson with obstructing a police officer in violation of NRS 197190, and Wilson was convicted after a bench trial in Carson City Justice Court. Wilson appealed her conviction to the district court, arguing that NRS 197190 was unconstitutionally overbroad and vague both on its face and as applied to her. The district court denied the appeal, holding that NRS 197190 was not unconstitutionally overbroad or vague because the statute required both due notice and the specific intent to obstruct a police officer. Wilson then filed this petition for writ of certiorari, which means she appealed to a higher court to review the decision of the lower court. And then within the body of this court case, the judges reiterate that NRS, not NFS right here, NRS 197190 only applies to physical conduct and fighting words. So just to reiterate, the higher court basically tells the lower court to relook at this case with their interpretation of, hey, this is a physical action. This is referring to obstruction is physical conduct and fighting words. So now lower court, take a look at this conviction in light of our interpretation of what obstructing a police officer actually is. Now, leave your thoughts in the comment section below. Do you think this Wilson case applies to the Chili DeCastro case? And if it does, then it's possible that we have a misinterpretation of NRS 197190 and it wasn't applied to DeCastro appropriately. Or do you think that DeCastro actually physically obstructed and used fighting words? I'd like to say to, Barry Cooper, yeah, let's have a conversation. I watched your video on the James Freeman thing. Within this video, he says that, to get an understanding of what he's actually talking about, we got to watch this 3.5-hour video, which I have not seen yet, but I'm still open to not only watching the video, but talking to Barry about this, because he basically says that James Freeman's interpretation of what happened with Chile is wrong and that the court was right to do what they did, which I don't understand that at all, but I'm willing to put myself in the devil's advocate seat to try to understand it. Because, the goal here is not just to make an argument so you can look like you're right. The goal here is to stay on the side of justice while it looks like everybody else is wanting to lean to the side of injustice. That's my view on it. Leave your thoughts about this for the world and the global thought, please, in the comment section below. If you haven't done so already, subscribe to the channel, hit the bell notification icon, give it a thumbs up, share it with everybody you know. Don't forget to subscribe to my email list or my website, highimpactflicks.com. If you want to support the channel further, grab a shirt, become a channel member, but more importantly, understand that freedom is dangerous. The only thing more dangerous is not having freedom. I will see you in the next video.